The broadcast is now starting. All attendees are in listen-only mode.
Hello everyone, this is Matt Keister. Welcome to the webinar, which is on the role of mediation in the IEP in Section 504 process. And this webinar is intended for families and professionals who help families in this process. I am a licensed attorney here in Vermont, and I work at the law office of Claudia Pringles in Montpelier. And Claudia has a practice in the field of estate planning. I also do involuntary guardianship cases in probate court, and I am the parent of a child on the autism spectrum, and that's how I got involved in this line of work. Just a quick legal disclaimer. The following presentation is intended for educational purposes only and is not intended as a substitute for legal counseling. So here are the topics for today on the mediation process. First, we'll talk about the big picture and the basics of mediation. We'll go over some recent statistics of mediation in Vermont and nationally. We'll talk about some of the rules and definitely some of the benefits of mediation, as there are many. We'll talk about how to prepare and what to expect in mediation. We'll talk about the negotiation and agreement of the result of mediation, and we'll talk about what happens if mediation is not successful. And at the end, we'll have time for questions if there are any. So first, the big picture. So it's helpful to understand dispute resolution in general when you're thinking about mediation. And dispute resolution is composed of processes that are used to resolve conflicts. Mediation is obviously one great example of this. Dispute resolution occurs in many practices of law and is an excuse me, is an important part of special education law. You may have heard of ADR, or alternative dispute resolution, and ADR plays a major role not only in contracts, and IEPs are essentially a contract in the special education process. So it's helpful to think about how ADR applies to not only to other facets of the law, but to special education specifically. Dispute resolution offers alternatives to litigation, which is maybe one of the most important aspects of dispute resolution, and is an alternative to having the court decide a dispute. So specifically about how dispute resolution applies to special education law, mediation is one of the most common and successful forms of dispute resolution in special education law. And we'll talk in a second about how successful it actually is. And then other examples of dispute resolution in special education law are a resolution session after filing a due process complaint, and then proceeding to due process hearing, and an administrative complaint with the state. These are all other examples of dispute resolution in special ed law. And these are mediation and other forms of dispute resolution are all important elements of procedural safeguards, which are in part codified in the Individuals with Disabilities Education Act, or otherwise known as IDEA. So it's helpful to understand how one gets into mediation, and it usually involves an impasse between the parents and the school involved. Mediation is a great possibility or a great option to consider after reaching that impasse between the family and the school in the IEP or 504 process. And that impasse is usually related to an important substantive disagreement. And this could be really about just about anything related to the child's IEP or 504 plan. It might involve placement or eligibility or services or any number of issues where it's difficult to reach an agreement with the school. So here are some specific examples, and obviously these are just a few examples of many possible reasons why one might end up in the mediation process. One example is if parents believe that their child should be receiving 15 hours a week of SLP services, but the school is only offering 5. So that would be one an example of services. If for instance parents feel that they should be getting a lot more services than the school is willing to provide, excuse me, and they've gone through the IEP process and they've had meetings, and the school is just not feeling comfortable with providing those services, then mediation might be a helpful alternative to the IEP process to resolving that dispute. Another example would be the child not being offered extended school year, or otherwise known as ESY services, over the summer, and perhaps the child would be at risk of loss of progress if they're not receiving those services. And this often relates to critical skills like reading, where, for instance, a parent feels that the child should be receiving X number of hours of reading services over the summer, but the school, for whatever reason, is not willing to provide it. Mediation might provide a way to resolve that issue. And then lastly, another example, child not receiving technological or visual or verbal aids which the parents feel are necessary. So to request mediation, the first part of the process involves filling out and submitting a form. Excuse me. And the Agency of Education website has that form available, and I've included the website address at the bottom of the screen here. And it's relatively straightforward. And families can request a mediation without filing a due process complaint. So if, for instance, they're in the middle of the IEP planning process and no due process complaint has been filed, but they feel like they've reached an impasse, it's not necessary to enter into the due process process in order to request mediation. You can request mediation at any time. Now, that said, if you do enter into the due process then you can also enter into mediation after that as well, and that can be a helpful way of resolving the issue once you're in the world of the due process complaint. Another point that's worth noting, the school can also be the ones to request the mediation, and families can agree to that or not, as I'll discuss in one of the next slides. Mediation is always voluntary on both sides. So here are some helpful statistics just to paint a picture of how useful mediation can be. So you can see the date range at the top of the screen, and that's a year's worth of data. And during that time, there were 24 mediations held in Vermont, which is a very low number compared to most states, just because of our smaller population. And 7 of those 24 were due process mediations, meaning that they were mediations that the parties entered into once the due process had begun. And then 17 of 24 of those are not related to due process. So most of the mediations, about 2/3, were related to were not related to the due process area, and then about 1/3 were related to due process. Now, of that total 24, 17 of those 24 resulted in an agreement, so 71%. And that's a pretty high number, considering the fact that before the mediation, both parties would have been at an impasse and would not have been able to move forward. And that represents a pretty high degree of success. And so broken down further, 4 of the 7 due process mediations resulted in agreements, and 13 of 17 that were not part of the due process resulted in agreements. So it's not a huge difference, the success rate between the two, whether it's part of due process or whether it's not part of due process. Fully adjudicated due process hearings are rare in Vermont, particularly compared to some other states, more litigious states. There was only 1 in Vermont last year. And there were 9 resolution meetings in Vermont, and only 1 resulted in agreement. And we'll talk more about resolution meetings. But just based on the statistic, it's very clear that mediation is much more successful than resolution meetings. Excuse me. Nationally, 66% of mediations result in agreements. So you can see again that number is pretty consistent with the state success rate. And I've included the web address for the source of these statistics at the bottom of the screen. So let's go over the benefits of mediation. There are many benefits of mediation, as I mentioned. First, there's a lot of room for creativity in the agreement process, and it's much less formal than it would be in due process, which is really nice because it means that when the parties come to the table, there's the opportunity there for each party to be creative about how they reach an agreement. Whereas in the due process you're leaving it up to a hearing officer who may not have as much room for creativity. It's really nice, the mediation, that you actually have a hand in crafting the result. You have more control over the outcome, which is great. Again, comparing this to due process, you're leaving it up to somebody else to come up with the result, and that person does not know your child or does not know your family, and quite frankly doesn't even know the situation all that well as you do and as the school does. So the result that they come up with is not necessarily going to be, at least in the parent's mind, in the best interest of the child. Parents that I've spoken to that go into the mediation process often genuinely appreciate the whole process, and they leave feeling very satisfied, obviously, particularly when it results in agreement. And they sometimes say that this is the most pleasant or friendliest interaction that they've had with the school. Along those lines, they're very pleased with the fact that there's no cost associated, and that the process is much faster than a due process hearing. As I mentioned before, mediation is voluntary on both sides. So you as parents are not required to enter into mediation if for some reason the school wants to bring the parties to mediation. And along those lines, if you as parents want to enter into the mediation process and the school is resisting, they also have the right to not enter into the process. It truly is voluntary on both sides. And if you start the negotiation process at mediation and you're feeling like it's just not productive, you're able to end the process at any time. And same is true for the school. If they feel like it's not productive, then they're able to end the process as well. You can't be ordered to agree to anything or forced to stay if you reach an impasse at mediation. And mediation can't be used to deny or delay the parent's right to a due process hearing. everything said in mediation is considered confidential, which is a huge benefit. It means that you as parents and the school can feel like you can speak freely and that you can, again, be very creative about possible options. And none of those things that are said are going to be held against you. If, for instance, you enter into due process later on, that these conversations that you're having at the mediation table are not going to be brought up. They're not going to be considered open to discussion in later discussions. So it's great that both parties have the ability to speak freely to resolve the differences, because otherwise you as parents or even the school might feel a little restricted in what you're able to say. These are just some rule citations that you can use if you want to look up the rules themselves. And I've included the web addresses for those as well. So next we'll talk about how to prepare and what to expect in mediation. To begin with, you want to clarify what your desired end game and your bottom line is before you enter into the process. You as a family or as parents or as your side of the IEP team would want to discuss what you're actually hoping to get out of mediation. And you want to be prepared to discuss how to move forward. That is, you want to be ready to negotiate. Um, you want to feel like you're able to potentially give some of the things that matter less to you up, and that you want to be clear on exactly what you are not willing to negotiate away. You do want to come to the table ready to advocate for the desired elements, and you want to ground your requests in fact and in law. And obviously, though you're not expected to prepare a case, you want to bring whatever documentation might be helpful to support your desired elements. And now, to clarify that, this isn't court, so you're not expected to prove anything, and you don't have to show documentation to support your case. But it's always helpful to be able to refer back to important documentation when it's relevant. It's also, really helpful to have realistic expectations about what you're hoping to get out of the process. And so, just to clarify, parents are not likely to get, or very, very unlikely to get, money damages out of the process. Schools are unlikely to apologize or admit wrongdoing in this process. And I caution parents to not hold out for getting anyone fired or the principal written up. That shouldn't be the ultimate goal of the mediation process. And as I mentioned, the request should be grounded in law. It should actually be reasonable request. And also, as I mentioned, you're working to settle a dispute, so it may involve compromise, and that's why mediation is so successful. Going back to those statistics, is because it usually involves some amount of compromise on both sides, and that's how the agreements are reached. So it would be helpful to have a fallback plan and be prepared to give something away. So here's an idea of what you can expect as far as the people that will be involved in the process. It's helpful to have both parents there if possible. It's also helpful to have a support person, like a good family friend or a neighbor that the family is close to, just there to support the parents, and potentially another family member, for instance, a grandparent or an aunt or an uncle that's very familiar with the issue at hand. And families are definitely not required to have an attorney to go to mediation. That's an important point to stress, is that regardless of whether you choose to have an attorney there or can afford to have an attorney there, it's very helpful to enter into mediation if that could be of benefit to the situation. And please do not resist the idea of going to mediation um, if you feel like having an attorney there is not an option. And that said, if it does feel like an option to the family, then um, it is a good idea to have an attorney there if you're not comfortable negotiating in the process. But again, please don't decide not to enter into mediation simply because you might not be able to have an attorney there. And there are other alternatives. You could bring an advocate, and there are some wonderful advocates available that would be able to help in situations like this. And then it's also helpful to know the mediator's role in this, and they're a neutral third party. They truly are not going to make a decision one way or the other. They're simply there to facilitate the conversation, to help advance the conversation, to potentially help the parties reach an agreement. And they are required to be impartial and qualified by state law. The school obviously would also have a presence at mediation, and there would usually be at least 2 or 3 school professionals there. Typically, they would be the members of the IEP team, and the school district should be sending anyone necessary to commit resources to resolve the issues. So, for instance, if you're hoping to get more services or one of those technological aids that we referred to earlier, anything that's going to result in the school having to spend money and authorizing some expense, you want to make sure that the school actually does have someone there that's able to commit resources to resolve the issues. So, this could mean that that all IEP team members are there, that are present for the mediation. And it's helpful to know that unless the parent brings an attorney, that the school can't bring one. So if you don't have an attorney there, then the school won't have one there either. So this is just a window into the dynamics of the day of mediation. It should occur at a neutral, comfortable location, ideally someplace where both parties feel comfortable. So, I tell families it's best if it's not the home turf of the school, so not at the school, because you may feel like you're sort of in the lion's den trying to accomplish things if you're at the school. And the mediator will explain the process, the basic ground rules for mediation, and then the mediator may shuttle back and forth between the two parties, the school and the parents, and the mediator might also bring the parties together. And there may be this sort of sequence of bringing the parties together, then separating them, and the mediator meeting with each, and then bringing them back together. Ultimately, it's just the objective is to advance the conversation. So there will be plenty of opportunity to speak confidentially with the mediator. If, for instance, you're in a conversation with the school present, and you're feeling like you want to speak confidentially with the mediator, you would feel very free to do that. And as I mentioned, the mediator will be neutral, so you should feel comfortable confiding in the mediator. You should also feel comfortable openly and freely discussing the issues and asking questions if there are things that come up that you're not sure of or don't understand. and try to remain as relevant to the issue as possible. This day of mediation wouldn't be the best time to vent just for the sake of venting. Ultimately, you want to advance the conversation, and often an agreement is reached, as we've pointed out earlier. So let's talk a little bit about what the negotiation process looks like and how agreements are arrived at. If you have a list of proposed remedies from a due process complaint, if you're already in due process, then that's a good place to start. And the school may respond to those with what they're willing to do, or they might respond with a counteroffer. If you have an attorney there, your attorney might bring a pre-drafted settlement agreement, and that might help to expedite the process. And the attorney might, for instance, have their laptop there and be ready to shift things around on the settlement agreement if the conversation advances in certain ways. And I think I stressed this earlier, but I want to mention again that you do want to focus on solutions to the issue. And that may involve being prepared to negotiate with some of the less important elements, and meanwhile keeping your bottom line in mind. Some families are surprised at how long this process can take, and it really can take a long time. You should plan on a full day. It may not end up taking a full day, but sometimes it does. 5 to 8 hours is not unusual for the entire process, especially for a productive mediation session, because sometimes it really does take a while to overcome some of those impasses. And as I had mentioned before, the mediator will often be shuttling back and forth between the two parties, so there will be some downtime when the mediator is discussing with the school. So you would want to be prepared for lots of downtime. So bring a laptop or something to occupy your time. And it's helpful to think of short mediations as being the sort of the typically unsuccessful mediations where the impasse is reached quickly. The mediations that wrap up really quickly tend to be the ones that are not successful and not resulting in an agreement. So what does an agreement look like? There would be a written agreement that the parties would come to if the parties are able to come to terms. And agreements usually involve some give and take on both sides. Schools are most likely to agree to something for a year because an IEP is for a year. So the agreement usually looks like the IEP does, in that it exists for a year, and agreements are legally binding and enforceable. So here are some things to keep in mind when you're in the process of coming to an agreement. An agreement can contain specific timelines regarding when things happen, and again, that failure to do so is a breach of an agreement. And it's helpful to have language in the agreement that would indicate what would happen in the breach of an agreement. It's usually unhelpful to settle for, okay, let's just go back to an IEP team meeting without an agreement. This doesn't advance the conversation any further. The point of mediation is not to treat it as just another IEP team meeting. It's to treat it as an opportunity to truly come to an agreement, to overcome an impasse. So if you're a little ways in and one party is suggesting that an agreement's not be the result of the conversation, that you just scrap the mediation and go back to the IEP team meeting process, then I would kind of resist that and keep trying to work toward an agreement. The language in an agreement should be clear, and if it is clear, then it would be more enforceable. and you don't want to give away or waive your basic rights. An agreement becomes part of the child's school record, and you as parents would have 3 days to rescind any signed agreement. So if, for instance, you walk away from the mediation session and you review it, or you have an attorney review it and you realize that it was not favorable to your situation, then you do have 3 days to get out of the agreement that you entered into. And if it's possible, it's nice to have an attorney review the agreement to make sure that it is favorable to you, and particularly if an attorney was not present at the mediation. But again, if having an attorney review it is not possible, then it's still definitely worth going through the mediation process. And for those instances where mediation is not successful, you do have the option of entering into due process. And if, for instance, you haven't already filed for due process, then you have that option after the mediation, after the unsuccessful mediation. And if you have already filed for due process, then you can just continue on through the due process steps after the failed mediation. As we discussed earlier at the very beginning, a due process resolution session or resolution meeting would be mandatory unless the parties enter into mediation. So if, for instance, you were in mediation and you reached an impasse and then you decided to go through due process and you didn't want to do mediation again, then you would end up in a resolution session. And here are some of the differences between a resolution session and mediation. It's not confidential, so the things that you say there could be brought up in the due process hearing. The agreement rate is much lower than mediation. It's not as successful in the parties coming to an agreement. It is legally binding, like mediation agreements, and it is enforceable in state and federal court. And like mediation, you have 3 business days to void any agreement that you make in a resolution session. And you may be somewhat familiar with due process hearings. As I mentioned at the very beginning, given that Vermont is not a very litigious state, a fully adjudicated due process hearing is pretty rare in Vermont. I think there was only one last year. But sometimes they are truly necessary. Sometimes you go through mediation or a resolution session and you're just not making progress, and you need to move forward to work on behalf of your child. And due process has a reputation for being time consuming and lengthy. So it can be a major endeavor. It can be quite expensive if, for instance, you have an attorney present and you don't reach a settlement with the school. The success rate is not great. It's less than 50% for families, but in some situations it is truly necessary. So don't let that discourage you if you feel that it really is an important next step. And in the due process, the school district can appeal if you are successful, so it can continue on to federal court. Like the appeal process from the due process arena, you can proceed to federal court if you're unsuccessful in due process. And you just want to be mindful of deadlines as far as filing to get heard in federal court after due process. And in federal court, additional evidence can be heard, and the decision is based on the preponderance of the evidence. So I'm looking at our list of questions, and I'm seeing that there aren't any questions. So this would be the conclusion of the webinar. And I want to thank everybody very much for attending. And here is a website that you can use to find me and contact information if you have any additional questions. Thank you very much.